Hello everyone. Today our topic is about contingent contracts in Indian Contract Act. Coming to introduction, uh, first of all, let us know what is meant by contract. A contract is an agreement between two parties which creates benefit to each other who enter into legal obligation. The word contingent means that an event or situation is contingent, meaning it depends on another event or fact. Like we all know that for an agreement we have two parties to enter into a contract. Like one example, to earn money you need to find a high paying job. Now contingent contract, it means that the enforceability of that contract depends directly on whether or not an event occurs. Like section 31 of Indian Contract Act 1872 particularly deals with contingent contract as follows. Now coming to next part, a contingent contract is a contract to do or not to do something if an event warranting that contract occurs or does not occur. Like we all know that simply we have to put a conditional contract is a contract in which the promisor only performs his obligations when certain conditions are met. Like where the contract occurs or the contract was happened, the promisor must be taken in place of the two persons who entered into a conditional contract. Like insurance, indemnity and warranty contracts are some examples of conditional contracts. Basic elements of conditional contracts. After considering the definition of conditional contract given in section 31 of the Act, the basic elements of the term conditional contracts are deals with as follows. Here, there must be a valid contract to do or not to do something. Likewise, section 32 and 33 of the Act make performance of contract conditional on occurrence or non-occurrence. Coming to an example, a contract is only valid if it involves the performance or non-performance of an obligation. If X is a contract with Y to buy Y's dog, if X survives Z, this contract can only be enforced at law if and until Z dies during X's lifetime. Now here, through this example, we have know that the X will become contracts to Y like an agreement and to buy Y's dog. Here the survival of Z occurs, the contract can be enforced at law if and until Z dies during X lifetime. Now coming to conditions that make a contract invalid. Article 32, it states that if the event occurring in the contract becomes impossible, the contract becomes void. Coming to illustration, Mohan agrees to pay Ram a sum of money when Ram marries Geeta. Unfortunately, Geeta died before being married to Ram. Here, the contract becomes void, where the conditions makes the contract invalid under the conditional contingent contracts. Let us discuss about Article 35. A contract with a condition to do or not to do something if a specific uncertain event occurs within a fixed period of time, and it will be void if at the end of the fixed period of the event does not occur or it before the appointed time such event becomes impossible. First of all, we see the example like Saura promiser to pay serfs if a certain ship returned within a year. The contract will be void if the ship is burned within a year. Here, the contract which entered into a condition which had to do or not to do something in a specific uncertain event, then it becomes impossible, or such period of time with such period of time or such end of the period of time will becomes automatically void and impossible document or contract. Now, let us see Article 34. If a future event on which the contract depends on a person's course of action at an intermediate time, then that event is considered impossible. When that person does something that causes the other person to act that cannot be acted upon over a certain period of time or in other situations. Here, it states that in a future event on which the contract depends on a person's course of action and which is considered by intermediate time, it is impossible. When the person does something that causes or other persons to act, then the act done by the person is cannot be acted upon. So these over certain period of time or in other situations which is stated under Article 34. So coming to Article 36, Article 36 states that agreements that are conditional on doing or not doing something, if an impossible event occurs, are void whether or not the parties to the agreement know of that impossible event at the time it occurred, it was still signed. Here, in this Article 36, it describes that agreements which are in conditional on doing or not doing something, the act, which is an impossible event, occurs when it is void. Automatically, we all know that contingent contract which is impossible, it automatically convert into void contingent contract. So, here within the time prescribed period of contract will be considered as void, valid, otherwise it will be taken unvoid, and it occurred, it was still signed. So here Article 34 and Article 36 of Contingent Contract Act should be taken as important articles under this Contingent Contract Act in Indian Contract Act in 1872. Now, coming to next part, business application of conditional contracts. First one is, issuance is a contract to do something. If a future event occurs, then the event will be contracted by the parties and the liability will be assumed by the offerer. The second point is, in all types of insurance such as life insurance, marine insurance, fire insurance and other types of insurance, the offerer undertakes to bear the risk of the offeree against the incident of doing or not working. Coming to third point, something and for this the recipient agrees to pay a certain amount. Conditional contracts can be used in warranty contract as well as in guarantee contracts. Here, coming to business application of conditional contracts, insurance must and should be need to enter into a contract to do something in a future event. When future event occurs, the contracted by the parties are liability to assume the offerers. In all types of offerers or insurance such as life insurance and etc., to bear the risk of the offeree against the incident of doing or not working. Now, something which is occurred to the recipient which agrees to pay certain amount in that certain agreement which was made by the parties, the conditional contracts can be used in warranty contracts as well as in guarantee contracts. Like warranty, we know that the warranty becomes a warranty under the parties becomes valid, as well as guarantee contracts must and should be entered into the valid contracts. Now, let us go with conditional guarantees, which are often used when the supplier does not have a relationship with the counterparty. We can use conditional contracts in negotiations. Conditional contracts often rise in when negotiating parties cannot reach an agreement. We can also use contingent contract in mergers and acquisitions, like M&A. Depending on the M&A transaction, contingencies such as earnings, sellers' notes, and buyer's shares may be part of the seller's proceeds. Once the transaction is completed, these backup payments will require ongoing contract between the buyer and seller. It can also be used in compensation contracts. Now, we all know that conditional guarantees, which are often used to the suppliers, does not have a relationship to enter into a counterparty, and these are contingent contracts, mergers and acquisitions. To reach the agreement, depending upon the mergers and acquisition, they can shade the parties of the seller's proceedings. Now, only with the transaction, when the transaction is completed, then it will be recurrent ongoing contract between the buyer and seller in compensation contracts. I would like to conclude the contingent contract. What is described in the contingent contract is known as English law, and for a conditional contract there is a certain event that must be occurs. In terms of these contracts, it is certain and depends on whether a future event occurs or not. A contract is a contingent upon how a person will act at a future time. Then the event is considered impossible when the person does anything which makes it impossible for the event to happen. So here, the conditional guarantees which often rises that the act which happen in future or future time or future event which is considered by the contract agreement to be impossible when the person does anything which makes it impossible for the event to be happen, and the term of this contract is certain and depends on whether a future event occurs or not. Thank you all.